Hi, good day. My name is Dino Mazzone. I'm a partner at Gattuso Bouchard Mazzone, and I'm glad to be doing this legal series with you today. My guest is none other than my wife. She's Barbara Farina. So today I think what we're going to talk about is shareholder agreements. And what I wanted to speak about specifically was the drafting of shareholder agreements, some of the things you should keep in mind. Now, again, for those of you who've done these type of agreements, this may be a traveled kind of route. You've already heard some of this, I'm sure, if not all of it. But I wanted to, certainly for the younger lawyers who are watching this episode and those who are concerned about some of the issues that come up in drafting a shareholders agreement, to keep these issues in mind. So one of the first things, Barbara, I wanted to talk about is, and this I'm sure happens all the time. I mean, I'm sure you've seen this happen, which is people come to see me. They want to, a group of individuals, they have a new idea. They want to create a new company. And they say, okay, we want to incorporate a company. And do we need a shareholders agreement? That's always one of the first comments, or certainly it's something I bring up at the time of incorporation. And the answer to that is invariably, yes, you need a shareholders agreement. Now, again, the pushback I get all the time, and it makes me crazy, is I'll hear, well, look, we're just starting. We don't really know if the business is going to go anywhere. And, frankly, there are times that I'm mindful of that, and I'm like, okay, look, if certainly cost is an issue, if it's a startup, you kind of listen to some of that argumentation, but I'm still very leery to let anybody get into a relationship to have as shareholders, as partners in a corporate entity without an agreement in place.
Absolutely, it's a document that governs the relationship among the shareholders, and whether you're related as shareholders or you're third parties as shareholders, it's really important because it's an operative document that if things are going well, you'll probably never look to it, but when things go sour, you'll be grateful that you have it in place.
And that's what we always say, right? We always say, look, your goal, your hope is that you sign this thing, you put it in a drawer, and you never look at it again. But like you said, if something goes off the rails, you have at least a document where people can point to and say, how do we deal with this situation?
Like a marriage contract or a prenup.
Well, in those situations, it's a little different. But so here's the thing, right? One of the comments I get whenever I do try to explain the benefit of having a shareholders agreement is I'll hear, well, I trust my partners. We don't need one. We're good friends. We know each other. And it's a comment that I'm always like, even to this day, it just grinds on me, because what I then need to explain, what I need to educate the client about is your business partners in a relationship. Today you're dealing with this individual. Maybe this person was great at playing baseball with when you grew up, or is a lot of fun to hang out with when you're going to a party, but you don't know whether or not this person is going to turn out to be the business partner you thought he or she would be. Or frankly, somebody gets sick, somebody dies. Do you want to deal with somebody's family who's taking over the shares? So these are the things that I try to impose, and I try to really draw attention to, so people can understand, why would I need a document so early in the at this stage in the game?
It's a roadmap. It's a roadmap, and it's a document that governs the relationship. It governs how you're going to approach certain decisions. It's going to discuss the vision, and it's an important document to put in place because it just sets the roadmap when discussions do deteriorate and where the relationship is no longer there. And it's money well invested in my
and it's preventative, right? The whole goal is preventative, as you would any other service in life, insurance, dental care, etc. It's the same idea. One of the things that I would like to counsel certainly lawyers to consider is when you're meeting with a client who makes it clear to you that, well, look, I don't want this agreement in place. I usually protect myself as a lawyer, and I literally will send a letter to the client saying, I've explained to you the virtues of why you should have an agreement. You've decided not to have the agreement. And frankly, I keep that in my file. And I just think it's a good, it's kind of like, if you want to call it good governance, if you will, as being an attorney and trying to make sure that you protect yourself, because people have very selective memories later in life when things go bad. And they're like, well, how come we didn't have this agreement? Well, we tried to talk to you about it years ago and you don't want to do it. So that's just a little piece of advice. The other thing I'd mention is that when we have these discussions about shareholders agreements, again, invariably I'll have people say to me, well, can't I, how much is it going to cost? Or can we just get a good model? And again, they grind on me, right? Because for me, at least, the goal is to try to draft something that's tailor made to the situation at hand. And
that is flexible enough to grow as the business grows.
Yeah, absolutely. Yeah. And so what I like to do is I spend a lot of time in the beginning before I even look at if you want to call it a model to start working with to try to sculpt. What I try to do is I want to understand the intent of the parties. What are you really trying to achieve with this business? Where do you want to go? What are your aspirations? What do you expect Joe Blow to do? What do you expect Mary Jane to do? What are your expectations of the relationship?
How are day-to-day decisions going to be carried out?
Do you see yourself in a growth phase in the next 1 to 3 years? Are you going to be spending money? These are the conversations I like to have.
Are you going to be needing money?
Well, that's we're going to get into that. And so that early conversation to really understand what is it that you're trying to achieve, big picture, with this company, with these people, I think is fundamental to drafting a really good shareholders agreement.
Absolutely.
And I'm going to be blunt. I've been doing this now for 32 years. I've seen a lot of really bad shareholder agreements. And I think it's because of some of the things I've just mentioned right now, which is there is this resistance, if you will, on the part of lawyers to really delve into this in a real way. They're getting the pushback from the clients to get a document out right away, to get something in place, to just, quote, protect us. And there's not a lot of proper thought given to the drafting of these shareholder agreements. Exactly.
And if proper thought is not put in, it can make a regular small process become a very burdensome process. It can cause risk to the company. It can just impact. So it's really a fundamental document. It's perhaps in a contractual relationship among shareholders or partners or whatever the vehicle is, perhaps the most important. And especially if, and I'm certain you're going to talk about this, especially if you have partners of varying degrees of interest in the company. Do you have a partner that, has a big stock of equity? If they have control, this is another concept I'm sure you're going to talk about. Or do you have minority shareholders? Do you have institutional shareholders that certainly have certain rights? Like it's really very fundamental. And the more you tailor it to the company at the beginning, the more time you'll save later on.
I couldn't agree with you more. I think so much of that is lost in the drafting process, and so much of it is negotiated away by the lawyers themselves. It's a shame, to be frank, and all it does is cause a little bit of heartache down the road. So I wanted to talk just generally the overview of an agreement, and for all of you who've touched these things, drafted these things. There's a buildup to the agreement. We get into like the early part of it with the definitions and setting out who are the officers, the directors. And one of the things I did want to talk about is a little bit on the definitional part of these documents. And by the way, one of the things I say all the time to my young lawyers whenever I'm mentoring or I'm supervising a document is good form leads to good substance. And I do believe that it's important that when we're thinking about concepts and defining terms that we're going to use later on in the agreement, we really give true thought to this. I'll give you an example. You'll see this all the time and we'll talk about how the idea about getting into an agreement, getting out of an agreement, how to buy somebody's shares. There are values that have to be attributed to all that. And you'll see in agreements the concepts of book value, fair market value. These are real important clauses. And they're not to be used in an interchangeable fashion where people don't know exactly where to use them. And I would suggest a very good accountant is a part of the process early on in drafting some of these clauses, particularly when you're talking about, for example, a dry cleaning business as opposed to talking about a construction business. The type of business you're in,
of course,
looking at how to value the EBITDA of a company could be different depending on the industry you're in. So these define terms. What does disability mean? We'll talk about that later. But what does disability mean? How we put clauses in there as to how the defined terms. That's going to have a bearing later on when we talk about whether some of the shares could be bought out or not. So give some real thought to your defined terms. Think about them. Don't just use a model and just put them in there. Think about what they mean for the particular clients before you. Now, even in establishing who are the directors, who are the officers. In addition, usually when we're talking about a small privately owned company, more than likely the shareholders are in fact also the directors, are in fact the officers. And we have clearly bylaws in place for most companies which give your standard kind of boilerplate definition of what a president is expected to do, what a secretary is expected to do. But what I like to do with my shareholder agreements is to really define specifically, if you and I were in an agreement and we were 50-50, let's say shareholders, I'd like to know what exactly is Barbara Farina going to be doing in this company.
Of course.
Like, if you're going to be the financial officer, well, here's what I expect for you to do as the financial officer.
A list of duties.
Absolutely.
A list of duties to keep everybody on track and to keep everybody honest, frankly.
And a list of duties where, in the event that something doesn't come to bear, where, for example, your best friend who you trust, the guy you went out with all the time that you thought was going to be an amazing partner, turns out to not really be hitting the mark when it comes to fulfilling his or her duties. You want to know, well, what does that mean in terms of the ability to remove that person from the company? Okay?
To remove that person, if there's if there's a repeated behavior of not doing
Correct.
their duties,
Correct.
Should we consider buying that person out?
Right.
Let's provide for a mechanism where if you're not holding up your end of the bargain, not only am I going to take away your officer role,
Right.
I'm going to maybe take away part of your shares, and guess what? I may take them away at a value that's not the fair market value.
And that's important. And that's like these vesting clauses where we make it clear
Yeah.
that